Hello and welcome back to Coin Lady channel. Two fascinating issues were raised by attorney Jeremy Hogan. In our current lunar family sedan room temperature jam, I'll be dishing both of them out to you. The initial one was raised by him just a few days ago on Twitter. Then he explained the primary argument for why XRP is not a security. And he provided a lot of information. And, because of that, and I get why a lot of people read that and are just thinking, of course, because we all know what's going on and are paying attention. Yes, we get it. XRP is not a security because it is not a currency. So, why can't we just get this over with? Why didn't Judge Torres just end this case already? Don't think so. It seems like it ought to be wrapped up by now. In the eyes of some, the case appears to be a slam dunk. So in answer to that, pretty recently, I don't know how many hours ago. Tonight, however, attorney Jeremy Hogan added his 2 cents, explaining why nothing is actually a slam dunk when it comes to this, despite the fact that I believe it is quite evident to us for good reason that we are on the right side of law and the right side of history. Hence, attorney Jeremy Hogan shed light on why the issue is more nuanced than was previously assumed. After reading his first thread on the subject just a few days ago, I can confirm that decentralization is a key factor in proving that XRP is not a security. This is correct since one element of the Howey test looks at whether or not the parties share a shared goal. But there is something I need to clarify before we go any further. I have zero experience in either the law or finance. You shouldn't buy or sell anything based on what I say or write because I am not a legal or financial advisor. Just a hobbyist here that occasionally posts films to YouTube on various crypto-related topics. Good, then let's begin with this initial thread. This first one is also from the recent past, only a few days ago. You only released the sequel a few hours ago. Yet, in the first video, he explains why XRP is not a security. What he wrote is presented here. The primary argument why XRP is not a security. First, XRP may only be considered an investment contract, not a security, according to the legal definition of a security. It's not a share of stock or a bond. And so on. The SEC agrees that this investment agreement is legitimate. And then he attached this screenshot to illustrate his argument. I won't bother reading the entire thing because it's already before your eyes. At least twice on my channel, I've read this in its full, and all it does is list examples of items that might be considered in this category. Then, we hear that the Howey case and its offspring control the study of investment contracts, as stated by attorney Hogan. The case's test, participation in an enterprise with others in the hope of sharing in the gains, was developed in reaction to a lower court's ruling that a high degree of risk was necessary. The Howey case was a response to a lower court ruling, therefore it did not dwell on the contract aspect of the investment arrangement. That's right. Just finished up the test's contract section and was about to start rendering the highway. Therefore, let this wave of thought sink in. Ripple's main legal argument is that there is no contract, and thus no investment contract, which we now know to be true. The SEC can now step in and say, hey, when you look at Howey, contract this, contract that. But that's because the lower court had already covered the topic implicitly. So, it was unnecessary to rehash all that supporting evidence once they reached the conclusion for Howey. In the end, that's the main point. Oh certainly, I don't want to lose my place in the Joyner case, attorney Hogan said. An enforceable, implied agreement or even an express legal agreement has just been discussed and decided upon by the court. In the Ripple situation, however, there were 2 contracts at play, one between the offerer and the buyer, and another, an investment contract. Neither an implied nor an express contract of investment has been argued for by the SEC. Instead, it claims that the purchase agreement is unnecessary and establishes nothing more than that. A simple purchase without more cannot be an investment contract, but the argument tears the investment out of the contract. Because this is so self-evident, there is not a lot of case authority directly on issue, yet, it is akin to purchasing an ounce of gold in that Ripple has no responsibility other than to transfer the asset. A state attorney is ultimately to blame for our current situation, by the way, so keep that in mind. Hogan, this makes no sense at all. Why would there be a ton of case law concerning this? So, that particular aspect of it is not present. There are, nevertheless, several favorable aspects that might benefit XRP investors in the long run. Here is what Attorney Hogan had to say about it. The Howie case makes it clear that all of the blue sky cases must be considered when defining an investment contract. They had all signed an agreement committing them to the investment. So, folks, regardless of how the agreements were worded, there was a contract with each of these. A lawyer named Hogan then chimes in, yes, how can a person legitimately, reasonably rely on an offer to make them a profit when they had zero legal recourse? When that opportunity falls through, they are unable to do so. The result of the often used four-part test may seem harsh, suggesting the need for a contract of some kind. Remember that the term security is not intended to safeguard a potential investment from their own poor judgment. Only offers subject to the disclosure requirements of the securities legislation need to provide particular information about the transaction into which the buyer is entering. There you have it, folks. That's also an important part. Consider that. The Securities and Exchange Commission has no obligation to protect us from ourselves in this regard. That has to do with coming clean. But we are well aware that the SEC is not concerned with the welfare of its investors and gives a hoot about their welfare. That is very obvious from their actions. Then, Attorney Hogan states that the question isn't whether or not Ripple used XRP proceeds to finance operations. The crux of the matter is whether the SEC has established that Ripple and XRP buyers entered into an express or tacit agreement governing the investment. This agreement did not exist. I hope this is helpful as you begin writing the decision. If you are the legal clerk for Judge Torres, please feel free to contact me for any more assistance. Sad face. Okay. That's a hilarious way to wrap up the discussion, though I will add that I pray they aren't only now getting around to drafting this blasted thing. At this stage, I would hope that a draft has been in the works for months. But I appreciate that it might take a long time to plan out the structure and methodology for something like this. In any case, it's a significant procedure. However, I have a sneaking sensation that we're getting close to the end. They are purely speculative at this point. Insight into that is not something I possess. In any case, after reading that whole conversation, I can see how that could appear to be a no-brainer to you. Then why is that? Why shouldn't we just keep on celebrating forever? Well, it's not that I don't think we have reason to be hopeful about the possible outcome here. I think we have reason to be excited that we're going to get a positive decision from Judge Torres. However, I don't think it's quite as much of a slam dunk on this topic as I think we like it to be. And the judge may easily make a mistake here. And, in reading this next section of Jeremy Hogan dissecting this is the section that he written up only a few hours or so ago. It's interesting that the case hinges in part on whether or not the judge is familiar with cryptocurrency, blockchain technology, and the meaning of decentralization. If the judge does, the case has a good chance of ruling in favor of XRP holders and against the SEC. If the judge doesn't, we might be in trouble. Okay, here's the most recent update from lawyer Hogan, a few hours ago. And this is his supplement to the information I just gave you. The SEC, he argued, is a major obstacle in the development of cryptocurrency. Many posters in the thread below have argued that the judge should make a quick decision because it's such an easy one. Not so. This is a complex legal struggle that could determine the fate of crypto as we know it. The SEC countered Ripple's claim that an investment contract requires a written agreement by pointing to several examples where no such thing existed, at least in part. The claim here is that Howie is applicable to virtually any financial transaction. The SEC's real argument is that points Nos. 2, 3, and 4 eliminate the requirement for a legally binding contract. In other words, the contract analysis is the shared business endeavor and the expectation of profits, thus he doesn't need a written contract. Let me be clear, I am not a lawyer and have no training in the law, but even a layperson like me can see that this is essentially what the SEC is stating, and so I conclude that there is no contract. For the sake of simplicity, we will argue that the Howie test's second, third, and fourth requirements have been met. That doesn't exactly pass the common sense test, does it? To wit, that. Is it just me, or what the heck makes it work? Since we can't seem to locate a contract, we'll have to go on faith that this is the case. That settles it. Lastly, the agreement is written down. Justice, do you think we can trust you? Is it possible that you might be fooled? But now they see this, I can't help but think about the SEC's treatment of this matter from the start. They'll keep throwing stuff at the wall until they find something that works. That sums it up nicely. The SEC wants its way on a number of areas of this case, and it is banking on the judge being either foolish, misinformed, or prone to making a mistake. To me, this is an entirely dishonest argument. There was no agreement. Therefore, they are the essential parts of a contract. It's not a contract in any legal sense. That's why it really annoys me. Hogan, the attorney, continues. The SEC has had early success in crypto lawsuits, which is bad news for Ripple. When crypto firms did not make post-loss obligations a priority. So, fortunately for Ripple, Judge Torres hasn't placed too much stock in the actions of her peers. If you look at the sex-related counterarguments and precedents, you can see why lawyers think Ripple is trying to get an appellate judgment on this issue. To the contrary, in my opinion, the evidence presented in the Ripple briefs is sufficient to warrant a favorable ruling by the trial judge. Its foundational principle is decentralization. That being said, I need to take a moment to acknowledge something, and I think Ireland is entitled to her opinion. Since they are the ones who genuinely know what they are talking about when it comes to local law, I do my best to avoid heated debates with local attorneys. Yet, you can be sure that the judge will decide in favor of Ripple because of what he wrote here. That is very rational. Just one more item I wanted to mention. I seem to recall Attorney Deaton saying, setting aside that perspective from Attorney Hogan there, or anything to that effect. Still, Attorney Deaton said, when you're talking about a higher level court, and I'm paraphrasing here, but he clearly conveyed the view that if he goes to an appellate court or, even more so, the Supreme Court, that these arguments are likely to stay. More likely to remain in such situation, in his opinion. And I'm not sure if I understand why you said it. I don't want to misrepresent what he might say, but if we're talking about the highest court in the land, I have to wonder. You can make educated guesses as to how the Supreme Court will rule on any of these issues by researching its current membership. In contrast, there is only one individual involved in district court proceedings before Judge Torres. So if just one individual messes up, we are all in trouble in the near run. Right. He reiterates, nonetheless, that a single factor is crucial. One of those things, according to Jeremy Hogan, is decentralization. Continuing, he said that the other case was dismissed because, from a conventional perspective, buying cryptocurrency smells like the unusual investment/purchase that Howie is meant to catch. But that's not the case here, as no sane person would buy something without the guarantee that they could sue the vendor if they were taken advantage of. Yet, conventional purchases are made through a single source. Securities have traditionally been sold through a limited number of large institutions. The decentralized nature of cryptocurrencies makes them a viable investment. Since the network is not owned by any one entity, it stands to reason that XRP might be bought as an investment with no need for a contract of any kind. This is the defining feature, and it's why I'm confident in the judges or clerk's ability to rule in our favor if they are well versed in the technological Ripple. It's possible that this case will go to appeal if the judge doesn't understand cryptography. But this is the final straw. A Howie analysis victory for Ripple is a major blow to the SEC, but it is not fatal to the cryptocurrency industry in the United States. It's not as simple as that, though. Against common belief, the Howie test has not become irrelevant. All that's needed is an update. Hopefully, our mechanic will be able to handle it, and we can close this chapter. That was a really beautiful approach to wrap up the discussion. For those of you who have been following along with my coverage of the SEC's Ripple case for the past 2 years, I have a confession to make. Throughout the course of the past few years, I have made it clear that I'm not quite sure that we need to completely discard Howie. For the most part, the legislation that would be required for this to operate with crypto already exists, I said. The lack of decentralization is largely to blame for this. Then, Attorney Hogan explained his meaning. It's been a while since I've said this, but the reason there isn't sufficient clarity in that this actually could be an easy fix if the SEC wanted there to be an easy fix for this is that if you cite what decentralization is and there are guidelines for that, Well, that plays heavily into whether or not there is a common enterprise, which is a problem of the definition of common enterprise. If a network is truly decentralized, then we need to agree on what that term implies and how to define it. But if there is no single point of failure, which would be a huge problem, then you've already solved a huge problem and are probably 90% of the way there. However, if it's decentralized, there can't be a common enterprise, and so it fails the Howey test. It doesn't make it a security. It's not that none of these solutions work, rather, they lack the necessary clarity to be used for cryptography. The issue lies there. You can now understand why lawyer Hogan chose to phrase it in the way he did. But I think it fits in very nicely with what I've been discussing for years. Thus, if the court is familiar with decentralization, Ripple should emerge victorious. Nonetheless, there is subtlety and possibility for error here. I believe it to be one of Attorney Hogan's larger points here. There is, of course, a tremendous deal of room for growth, but this is the current landscape. I don't claim to be a financial expert. Nothing I say or write should influence any transactions you make. Please like and subscribe my channel. See you later, bye.